Now that we understand express conditions, let's take a look at implied conditions. Implied conditions are key to understanding contractual obligations because they bring with it the doctrine of substantial performance. Most contracts assume that the parties are making an exchange of promises. Those promises are mutually dependent on one another, and they can be satisfied, at least to the extent that the other party's performance is due, by substantial performance. The notion is that A's promise to B is conditional on receiving B's return performance to A. But this condition is implied, not express, so B's performance is due when A substantially performs its promise. Complete performance is not necessary to cause B's duty to come due. Let's look at this visually. And we see here we've complicated the chart a little bit by showing there are conditions on both sides. One party's promise is also the condition that causes the other party's performance of its promise to come due. Likewise, the performance of the return promise or the consideration is itself a condition for the initial promise to be due, for performance of the initial promise to be due. If the parties are ready and able to perform, both would therefore be liable for breach, although if neither is liable and ready to perform, neither would be liable to breach, as neither condition has occurred and neither performance is due. But that's the complicated version. The simple version is usually one party has agreed to sell something or do something, and the other party's return promise is to pay. The question is whether or not the party has to pay, given that the goods are defective or performance is somehow not perfect. And that brings us to the doctrine of substantial performance, under which the payment is still due even if the performance is not perfect. The historic case of Kingston v. Preston identified these three types of covenants that we discussed earlier. Independent promises, whose performance has no impact on any other promise. Sequential dependent conditions, where one promise must be performed first before another performance is due, and mutual and simultaneous conditions which are to be performed at the same time. The restatement makes it clear that an exchange of promises, generally mutual and simultaneous conditions, is presumed. So implied conditions are the default state of contract law, except in cases proceeding sequentially or when another intention is clearly manifest. So in the world of contracts, the default is to presume there is an exchange of promises, to presume that the promises are dependent on each other. In fact, to presume that they are simultaneous conditions that are mutually dependent, although in many cases, particularly with services that are rendered over time, it makes more sense to construct them as sequential promises. Restatement 234 makes that point even more clear, that simultaneous conditions is the default interpretation, but sequential conditions are presumed when performance takes place over a period of time. And just to kind of put that into a chart, we see that sequential conditions, meaning they're sequentially due in order, are a type of exchange of promises, but we are going to default without any, other reason to believe otherwise. We would default to simultaneous conditions. If the sequential condition has not been performed, or if the simultaneous condition is not ready to be performed, then the other party's duty to perform is not yet due. But if the conditions are substantially performed, even if they are not completely performed, and the other party does not perform, then the other party is instead in breach.